Hi, Bill Henshaw here again, your resident constitutional kook, and we're at it again. And I've been asked by my friend, what my definition of excessive force would be, most particularly with regard to instructing a jury if it would ever get to a stage like that. And I said I'm going to take the absolutist position here, and I am. If you have a court that was out jurisdiction, then just about anything done by a cop to quote unquote bring you to justice is excessive force. And again, as I say almost every time out, I don't make this stuff up. I got the Supreme Court of the United States behind me on this. They decided a case called John Bad Elk versus United States. I don't have the citation on this one off the top of my head. You can send me an email at ccaspari@live.com. I'll get it to you. Probably Google this, it'll come up too, but nevertheless, I'll get it to you. And this is a case in which they reversed a conviction of John Bad Elk for murder of a police officer because what happened was, and this was in the state of South Dakota just after it was admitted into the Union sometime, but it was on a federal Indian reservation, which is what made it a federal case. And this cop approached Bad Elk and tried to arrest him without a warrant and without probable cause. A struggle ensued, the details of which I don't think were mentioned in the Supreme Court decision. But the result was that the court ruled that on the circumstances of this case, it would be hard to convict Bad Elk of manslaughter, let alone murder, for which he got convicted, and they reversed it, saying that at common law you had a right to self-defense. And we damn well have the same right today. I agree with that wholeheartedly, especially with these admiralty courts that they're pretending to be state courts of common law general jurisdiction. That fraud and deceit alone, not to mention treason, gives us the right to self-defense. So that's my absolutist position on it. With respect to other contexts, it doesn't lend itself to any easy way to pin down, what we're talking about here. But I would suggest, the case in New York, where the poor guy got choked to death because he was violating. Eric Garner got choked to death when he was, violating some kind of a panhandling law or what have you. It was clearly, there's no excuse for that. The cop wasn't in any danger. The crime, quote unquote, as far as I know, there wouldn't have been any jail time associated with it. And I think you have to judge it in that kind of a context. So excessive force in the case of Eric Garner would be one thing. Excessive force against a bank robber coming out of a bank might be another. Although, given my absolutist positions, again, if all he's holding in his hands are Federal Reserve notes, he hasn't robbed anybody of anything. Uh, but you get the point here. If you're in the commission, a position of committing a serious felony in which somebody is likely to be injured or killed, that's a clearly different definition of excessive force. What you're trying to do is save somebody's life. And in that case, taking the life of the person that's threatening the other person is clearly in order. Even if the court wouldn't have jurisdiction, I think there's probably not much you could do to prosecute someone like that. And I probably wouldn't attempt to do it under those circumstances. But it's a tricky business. I don't get it. Like Oscar Grant, for example, who got killed in the bar station when the thug confused his 9mm Glock with a taser. Now, I think a taser might well have been excessive force given the facts as I understand them about that case. And yet, here's the bastard only got, I think, an 18-month jail sentence and was released in like 12 months for good time. Right. So, yeah, it's an important question to sort out, especially if we get our governments back that we should have. And if and when that happens, now you're going to have public servants that will be responsible for their acts. And we will need some clear and unmitigated definitions of excessive force so that cops can be trained to know what to do and not to do. If it was me, for example, a lot of these cases, especially where blacks have been shot over the last 5 or 6 years, if you're going to do that, you don't shoot him in the back like you did with Stephon Clark up there in Sacramento. You shoot him in the knees or something and take them down where they don't pose any danger. In fact, there's a case to cite excessive force that I might, if I'm on a jury in a criminal trial of these cops for murder, which there should be one, I might take into account that maybe the area was dark and wasn't well lit, and they couldn't be sure that this guy did or didn't have a gun. But to shoot him 8 times in the back, all that would do for me, at most, would be to lessen the conviction from murder 1 to murder 2. 25 years to life. And it may get worse than that, because if you're out there as a cop and you haven't been properly trained and you haven't been properly equipped with gear you can use to determine at a distance, strong enough flashlight or whatever it takes to do it, whether a person is armed or not armed and what they're doing at the time, that's a bit of a problem too. Would that be a mitigating factor for me sitting on a jury? I don't know. I'm be against it right now, but that particular part of it could change over the course of time. It would depend on the facts of the given case. So yeah, it's a tricky business, excessive force, but just about anything, especially in the context of a vehicle code stop. That's excessive force, because you're not out there as a person required to have a license, and you'll love the legal definition of license, trust me, from Black's Fourth Law Dictionary. And you certainly are not a person required to have insurance on your quote-unquote vehicle, with insurance being admiralty, and admiralty subject to federal law, not state law. So all of that's excessive force, plain and simple. I mean, there's no question about it. So yeah, it's context specific, to be sure, but you get the idea. These are the kinds of nuances that you have to put into definitions like this. Whether it can be legislated effectively, hard to say. But you can train cops. This is what you do or don't do, as the case may be. And by the way, another big point here for me is, if you quit hiring these damn cops that were in the military and have PTSD and won't know one right from the other, they're going to think they're in Baghdad, Iraq, not San Francisco, California. And that can't be a good thing. If they can't make that kind of distinction, they do not belong out there with a badge and a gun. Behind a desk, maybe, but not in a situation where they can go out there and do what they damn well please and then claim they're going to have immunity against their subsequent civil rights lawsuit. That's not the way it's supposed to work. So I got up on a little tangent, sorry about that, but you get the idea. And if I have some more thoughts on this, I'll pass them on, and please feel free to ask me questions about this one. I'd be interested to hear your comments. Thank you.